You're listening to the Bloomberg Law Podcast. Catch us weekdays at 10 p.m. Eastern on Bloomberg.com, the iHeartRadio app, and the Bloomberg Business app. Or listen on demand wherever you get your podcasts.
I'm Kimberly Robinson.
And I'm Lydia Wheeler. We're filling in for June Grasso, who's out this week. Ahead in the hour, we'll talk about the fight at the Supreme Court over a $6 billion bankruptcy settlement that could release the billionaire owners of Purdue Pharma from all liability related to the opioid overdose deaths.
But first, we'll talk about the late Justice Sandra Day O'Connor, the first woman to sit on the U.S. Supreme Court.
So today, I'm pleased to announce that upon completion of all the necessary checks by the Federal Bureau of Investigation, I will send to the Senate the nomination of Judge Sandra Day O'Connor of Arizona Court of Appeals for confirmation as an Associate Justice of the United States Supreme Court. She is truly a person for all seasons, possessing those unique qualities of temperament, fairness, intellectual capacity, and devotion to the public good which have characterized the 101 brethren who have preceded her.
That was President Ronald Reagan, who nominated O'Connor in July 1981. The justice died last week at the age of 93. Joining us to talk about her trailblazing time on the bench is New York University law professor Melissa Murray, who co-hosts a podcast on the Supreme Court called Strict Scrutiny. Thanks so much for joining us.
Thanks for having me.
Hey, Melissa, I was wondering if you could start by telling us a little bit about how Justice O'Connor got on the high court bench. Just wondering, what was the moment like when she was nominated to the court as the first female justice?
Well, obviously, this is a campaign promise that Ronald Reagan made in sort of the wake of the women's rights movement. But when he had to actually go about finding a Republican woman to nominate, he didn't have a lot of choices on the federal bench. Republicans didn't really have a great track record of putting women on the bench. And in fact, most of the women who had been on the federal bench at that point had been appointed by Jimmy Carter, and that included Ruth Bader Ginsburg. So while there were a number of choices on the federal bench, they weren't necessarily ideologically aligned with Reagan and his electorate. So he had to look a little further afield. He cast his gaze across the state courts, and he settled on Arizona, where Sandra Day O'Connor had been a politician. She had been the majority leader of the Arizona Senate, and from there she had gone on to be a trial judge in the Arizona state system and then a judge on the Intermediate Court of Appeals in Arizona. And she'd been very active in Republican politics in the state, worked very closely with the Goldwater campaign, a real mover and shaker in Republican circles in Arizona, and she really rose to the top.
Now, despite being appointed by a Republican, Justice O'Connor became really a decisive vote on a number of big issues. We're talking abortion, affirmative action. So I'm wondering, can you tell us about a few of those notable decisions?
Sure. Even straight away when she joined the court, she definitely had some decisions that really have become canonical, the things that we teach now in constitutional law. One of them was a decision in the 1980s called Mississippi University for Women versus Hogan, which was a challenge brought by a man, Joe Hogan, who sought admission to a nursing program at the University of Mississippi for women, and he was denied admission because the program was exclusively for women. So this is a sort of predecessor to the VMI case that was later decided by the court in 1996. In that case, the University of Mississippi said this program is exclusively for women because we are trying to remedy the historic exclusion that women have faced in the employment market. And Justice O'Connor kind of did the smell test on this and was like, women really haven't had a lot of barriers to being nurses. This actually seems like a program that's rooted in a stereotype that the only kind of medical profession for which women are well suited is nursing. And so on that ground, she said this was not really a program where a gender classification could be upheld. This was something more insidious, more of a stereotype, and she invalidated it, and she got a majority of the court to do so. She would later go on to broker some really important compromises on landmark issues like abortion, for example. As a justice of the court, she evinced a real skepticism of abortion, not necessarily in whether or not a right existed, but whether or not the right existed and could coexist with the state's interest in regulating the procedure itself. And recall, she had been a legislator at the state level. And so she very much believed in the prerogatives of states over certain things like health and welfare. And so she really brought this to her judging on the issue of abortion. And she was the one who articulated in a series of separate opinions in cases like Webster and Thornburg this idea of an undue burden. And then in 1992, when the court took up Planned Parenthood versus Casey, this challenge to Roe versus Wade, she really had an opportunity to put that into practice. It seemed to everyone that the court was poised to strike down Roe versus Wade, but she, along with Justices Kennedy and Souter, formed a troika that really compromised on this question, reading the public mood, recognizing the interest in stare decisis. They brokered a compromise that would give states the opportunity to broadly regulate abortion while still upholding the idea that there was a constitutionally protected right of a woman to choose an abortion. And that was one of her most significant decisions. And you see some real glimmers of her interest in women's rights in that opinion. One of the provisions of the broader abortion law that was invalidated in that decision was a spousal notification provision that she said really endangered the lives of women in abusive relationships and made clear that women who were in marriages were not necessarily equal to their husbands in terms of decision-making authority. And so she did not like the idea that women would be subservient to husbands or would depend on husbands for making such a decision like this. And so she invalidated it and then, again, really emphasized the threat to women who were in abusive or violent relationships.
You started off talking, Melissa, about barriers for women that may or may not exist in the nursing space. Even once Justice O'Connor got on the bench, there must have been some barriers to being the first woman on the court. Can you talk a little bit about what that must have been like for her day in and day out?
She mentioned this a few times when she talked about her tenure on the court. Like, it was hard to be the first. I think she very much felt the weight of her historic appointment. And she said, very frankly, it was great to be the first, but she didn't want to be the last. She didn't believe that her gender necessarily said or influenced the way that she judged. She said, a wise old man and a wise old woman would reach the same conclusions. But it was really clear that in some of these cases, particularly in cases involving women's rights and gender rights, she very much came down in favor of women's rights and had perhaps a more keen eye for the kinds of injustices that women had experienced. And she experienced some of them herself. Very famously, she graduated near the top of the class at Stanford Law School and could not find a job in the legal field as a lawyer. She was told to get a job as a legal secretary, was offered jobs as a legal secretary. So, I think she understood that very well. And she also spoke about how much of a relief it was and a joy when Ruth Bader Ginsburg joined the court in 1993, when she was no longer the only woman on the court. And, they were two very different jurists, in some cases diametrically opposed in terms of their jurisprudence. But on the question of women's rights, they were often in alignment and voted together 90% of the time in women's rights cases.
So, Justice O'Connor was known for being the first female justice on the court, but she was also known for being the last justice to have any prior elected political experience, before she was confirmed to the court. Can you tell us more about that? I know you mentioned it before about, her time in Arizona, but can you walk us through what her background was there?
Well, I think to today's listener, the idea of a judge who is also a politician seems a little far afield because we just don't have that profile on the court anymore. I think the person who comes closest to it is someone like Justice Kagan, who had to be relatively political as the dean of Harvard Law School, but certainly was not an elected official in that way. But for a very long time, this was not an unusual profile for a justice to have. Earl Warren, very famously, came from California politics. Hugo Black had been a senator from Alabama. And Justice O'Connor, of course, spent a lot of time in the Arizona state legislature, and it did inform her judging. She very much believed in this question of federalism. She was one of the stalwart people on the court on the sort of new federalism that really sought to make a clear divide between the prerogatives of the states and that which was then reserved for the federal government, and making sure there was a clean line and that states maintained their regulatory prerogatives. She also, I think, applied those kinds of political experiences in the way she approached her colleagues and the way she approached judging with an eye toward where the public mood was, right? So she was very good at brokering compromises. I think the Casey decision stands out in that way. But she also was very adept at sort of understanding where the mood of the country was on hot-button issues and making sure that the court didn't get too far out ahead of the country or lag too far behind. And that often meant that she wasn't advancing a broad ideological or theoretical agenda about what the Constitution should mean, but rather was making very incremental, narrow decisions that really hewed to the four corners of each case that was presented.
Coming up on the program, we'll talk more with Melissa Murray about the late Justice Sandra Day O'Connor. Remember, you can always get the latest legal news by listening to our Bloomberg Law podcast on Apple, Spotify, or wherever it is you get your podcasts. I'm Lydia Wheeler.
And I'm Kimberly Robinson. This is Bloomberg.
You're listening to the Bloomberg Law Podcast. Catch the program weekdays at 10 p.m. Eastern on Bloomberg Radio, the TuneIn app, Bloomberg.com, and the Bloomberg Business app. You can also listen live on Amazon Alexa from our flagship New York station. Just say, Alexa, play Bloomberg 1130.
I'm Lydia Wheeler.
And I'm Kimberly Robinson, in for June Grasso.
You may be surprised that I'm promoting civics teaching and learning using online media. I'm not an expert in it, but these are the new tools of civic engagement for the digital generation, the young people. And even a retired cowgirl like me knows that we need to use these tools to educate if we're going to inspire and interest today's young people to become active and knowledgeable civic leaders.
You just heard Justice Sandra Day O'Connor introducing her online teaching tool, iCivics. We've been talking to New York University law professor Melissa Murray about the life of Justice O'Connor, who passed away last week. Melissa, Justice O'Connor's legacy was solidified long before she retired in 2006, but she continued to be a public servant for many years after her retirement, championing causes like judicial independence and civics education. Can you tell us a little bit about some of the things that she did after she left the court and, how that sort of compares with what we see from, justices who have recently retired?
Well, iCivics is perhaps the cornerstone of her post-retirement work. She did retire in 2005, and she wanted to be engaged. I think at this point in time, I'm only speculating here, but, at this point, I think she probably realized that her vote in Bush versus Gore in 2000, which propelled George W. Bush to the presidency and set the stage for John Roberts and then Samuel Alito to be appointed to the court, and indeed Justice Alito took her seat. I think she understood that had really changed the tenor of the court. It really sort of pushed the court in a rightward direction, and it was very clear, even before the addition of the Trump justices, that the addition of Justice Alito in her seat had really moved the court to the right. She had been among the majority in a decision to uphold the McCain-Feingold campaign finance law in McConnell, and that was principally undermined by a big part of the decision in Citizens United in 2010. And so, I think perhaps we might understand her work in civics education and focusing on young people. This was an opportunity for her to sort of re-engage this question about what democracy is, what is required of a democracy, and what is the role of a judge in a democracy.
Now, you mentioned her retirement before, and at the time, the circumstances were a little tumultuous, particularly as it came to the timing of her retirement. So can you tell listeners a bit about that?
So back in 2005, Justice O'Connor was dealing with this family situation. Her husband was suffering from Alzheimer's, and his needs had sort of ballooned, and she really did need to be with him more frequently. But she was also at the height of her authority on the court. She really was the fulcrum around which the entire court pivoted. And, if you wanted to form a majority, you needed Sandra Day O'Connor in most instances. But she did make the decision to step back because of these family responsibilities. When she stepped down, John Roberts was nominated by George W. Bush to fill her seat. And then very quickly thereafter, William Rehnquist, who was the Chief Justice at the time, unexpectedly passed away from complications from thyroid cancer. And O'Connor and Rehnquist were very good friends. They had known each other at Stanford Law School, apparently, according to her biographer, Evan Thomas, they had dated at one point in time, and that Rehnquist had proposed marriage and was rejected. So they were very good friends, but it seemed to come as a surprise to a lot of people, and no more so than her. And so when that vacancy presented itself, the president, George W. Bush, nominated John Roberts to fill the seat that Rehnquist had left unoccupied, and that left O'Connor's seat available. There was a lot of tumult around this. The first person nominated to fill that seat was Harriet Mier, who was part of the White House counsel team and someone that President Bush knew very well from his time in Texas. She was viewed with considerable skepticism from those in the then nascent conservative legal movement. She didn't really have a lot of bona fides with conservatives. She wasn't a member of the Federalist Society. Ultimately, she withdrew from the process, and Samuel Alito, who was perhaps a more conventional pick, was identified and was nominated to fill her seat. And, when asked about it, she made all of the very familiar gestures praising the nominee, but she did note that she wished it had been a woman.
Interesting. Yeah, I do want to make sure that we talk a lot about that swap for Justice O'Connor, for Justice Alito, and sort of all the things that have happened since then and what that means for her legacy. But first, just want to give listeners a little idea about, I think most people know a lot about her trailblazing career, but what about her upbringing? What was that like? Because that seems very different from a lot of the justices that we have on the bench today as well.
Well, by her own admission, she was a cowgirl from the American Southwest. She grew up principally on her parents' ranch out in Arizona, and not a super populated place. Ranches are notoriously isolated. This was no exception. She grew up with her brother and her mother and father and, the ranch hands who were there. There wasn't really an opportunity for formal schooling on the ranch. So when it was time for her to go to school, she went to El Paso, which was the nearest large city, which, at the time I think wasn't what we think of as El Paso today. But that was the nearest larger city where she was able to attend school. And she attended school while living with an aunt in El Paso. And then from there, she went on to Stanford University for college. She graduated early and matriculated at Stanford Law School, where she had a very distinguished career, more distinguished than her husband, apparently, and was a member of the Law Review, and then found as she graduated that despite her impeccable credentials, despite her amazing training, as a young woman, she could not actually get a job as a lawyer.
Kimberly alluded to this before about, how a lot has changed in some of the legal areas that we've talked about. Can you tell us, how consequential it was that Justice O'Connor was replaced by Samuel Alito on the bench?
I think lots of ink will be spilled in the next few months about, sort of what it meant to shift from a Justice O'Connor to a Justice Alito. First, Justice O'Connor very much was sort of the median justice, the center of the court, the swing justice. I don't think anyone would describe Justice Alito in that way. I mean, he is very firmly on the court's right wing, right flank. He's never really been in the middle during his time on the court. And in fact, I think he's probably moved more solidly to the right as his tenure on the court has progressed. In 2022, we saw Justice Alito write the majority opinion in Dobbs versus Jackson Women's Health Organization, overruling on a 5-4 vote Roe versus Wade and Planned Parenthood versus Casey. And of course, Justice O'Connor was absolutely pivotal in upholding Roe and brokering that compromise in Casey. We also see a very different set of votes from that seat in the arena of affirmative action. Justice O'Connor was very skeptical of race-conscious remedies. She was in the majority in Croson, a 1989 case that determined that strict scrutiny was the appropriate standard of review for any kind of racial classification, even ones that purportedly benefited minorities like affirmative action. In the most recent Supreme Court term, we saw Justice Alito with that 6-3 conservative supermajority to dismantle affirmative action in students with fair admissions versus Harvard. But I think another place where you see the real shift from a Justice O'Connor to a Justice Alito is just generally in the collegiality of the group. Much has been made in the last couple of years about a sort of eroding collegiality on the Supreme Court.
She just had a really, really remarkable career, and definitely very collegial. I'd heard that from several sources. But we really appreciate you joining us. That was New York University law professor Melissa Murray chatting with us about Sandra Day O'Connor's remarkable career. She's also the co-host of a podcast on the Supreme Court called Strict Scrutiny. Melissa, thanks so much for joining us.
Thanks for having me.
Coming up next on the Bloomberg Law Show, we'll talk about the $6 billion bankruptcy settlement involving Purdue Pharma that's being fought over at the United States Supreme Court. I'm Lydia Wheeler.
And I'm Kimberly Robinson. This is Bloomberg.
You're listening to the Bloomberg Law Podcast. Catch us weekdays at 10 p.m. Eastern on Bloomberg.com, the iHeartRadio app, and the Bloomberg Business app, or listen on demand wherever you get your podcasts.
I'm Lydia Wheeler.
And I'm Kimberly Robinson, in for June Grasso. Let's now get to the Supreme Court fight over a $6 billion bankruptcy settlement involving Purdue Pharma, the maker of the highly addictive opioid OxyContin.
In the views of the opioid victims and their families doesn't matter.
I'm not saying it doesn't matter.
I think you are. I think your position is saying it doesn't matter.
That was Justice Brett Kavanaugh expressing skepticism with the federal government's argument that the settlement should be scuttled. Bloomberg News reporter Jonathan Randles joins us to discuss. So, Jonathan, can you start by telling us what exactly this settlement does and why the Biden administration is fighting it?
Sure. So the settlement would resolve tons of litigation against Purdue Pharma and members of the Sackler family that own Purdue Pharma related to Purdue's aggressive marketing of OxyContin. And the reason the settlement is controversial is because it forces opioid victims who would be otherwise against the plan into the deal and forces them to drop their claims and their ability to present their case against the Sacklers to a jury, regardless of if they want the deal or not. So that's why it's being challenged by the Biden administration.
Is there anybody that supports this settlement, and if so, why?
Yeah, it's widely supported by different creditor groups. So, like, state attorneys general, uniformly support the deal. Different counties and cities, municipalities that are all trying to get money from Purdue and the Sacklers to pay for opioid abatement programs support the deal. And groups and personal injury lawyers that represent tens of thousands of opioid victims or claimants, people who either directly have been impacted by opioid addiction or family members who, say, have lost people to overdose, also support the plan. The reason why the people who are proponents of the deal want the Supreme Court to uphold it is because it provides up to $6 billion in funding. And, thousands of dollars for individual claimants that supporters say they wouldn't otherwise have available to them. So if the Justice Department's bankruptcy unit, it's called the U.S. Trustee Program, if they succeed in scuttling the deal, supporters of the plan say, billions of dollars in aid that they would otherwise receive would just evaporate, and they'd lose this money that is desperately needed to address the addiction crisis.
So, if this is it really for people who are seeking, some sort of relief, really the issue for them is this one particular provision of the settlement. Wondering if you can tell us what that provision is all about.
Yeah, so the jargony term for it is it's called a non-consensual third-party release. Purdue Pharma filed bankruptcy in 2019, and as a part of the bankruptcy, they reached this settlement with the Sackler family. The Sacklers are not in bankruptcy, but the settlement essentially extends the benefits of Purdue's bankruptcy to members of the Sackler family. And the non-consensual third-party release is the mechanism that binds individuals who oppose the deal to it. It's something that was first used in the late 80s and then authorized by Congress in the early 90s to deal with asbestos litigation, and it's been expanded over the last 3 decades to address all types of product liability lawsuits and waves of litigation over sexual abuse. So it's been used to resolve sex abuse litigation brought against different Catholic archdioceses, USA Gymnastics, Harvey Weinstein's former film studio, directors and officers of that film studio were the beneficiaries of this type of arrangement as well. And the thought is lawsuits can be complicated when there's, tons of litigation brought by hundreds, or in this case, hundreds of thousands of individual claimants. These types of deals, while, it's not great to force holdouts into a deal, the argument goes necessary to distribute a bankrupt company's limited funds as fairly as possible.
So does this actually protect the Sackler family from future litigation then?
Yes. Any claim related to Purdue's marketing or sale of opioids would be resolved or extinguished, however you want to describe it. Any future lawsuit that would be brought would, you can get into the specific legal mechanics of how this works, but it would essentially be blocking any future lawsuits against the Sacklers related to the opioid business.
What about lawsuits by the federal government? Would those be blocked if this deal gets the green light from the Supreme Court?
It would resolve civil lawsuits. So I think that the Department of Justice, it was probably 2020, the Department of Justice settled their civil claims against the members of the Sackler family for, I don't have the number right off the top, but I think it's $225 million the Sackler family agreed to pay to resolve the federal government's civil liability. So this would resolve, any kind of lawsuit seeking money against the family brought by the federal government or individual state authorities, local counties, or personal injury victims. It does not prevent any federal authority or state authority from bringing any potential criminal charges against anybody related to Purdue. But, the Sacklers have always maintained and continue to maintain that these are merely allegations. They've, deny liability and all wrongdoing, and of course, they've never been criminally charged.
Now, the justices today seemed really divided. There were several justices that were skeptical of the Sacklers' arguments, and others that were skeptical of the government's attempt to scuttle this deal. So can you talk about kind of where the justices were shaking out? Were they following kind of on their ideological lines here, or, was the divide kind of across the aisle?
The latter. It's kind of interesting. Bankruptcy doesn't always get as much attention in the Supreme Court as other more, and rightfully so, more high-profile or controversial or contested kind of legal issues of the day. So it's always kind of interesting when something from bankruptcy court finds its way all the way up to the Supreme Court, and as is often the case, as it was today too. This issue kind of cut through the normal conservative, liberal ideological lines. So you had Neil Gorsuch was pointing to the fact that, by stripping holdouts potentially of the right to a jury trial, that raised constitutional problems potentially to the deal. And you had liberal justices, raising different arguments against it, like the fact that Purdue transferred it was $10 billion in funds from the company between 2008 and before they filed in 2019. The point being that the reason why Purdue says it needs this settlement is arguably because the Sacklers took money out of the business before bankruptcy. I think that was Justice Jackson who raised that point. So a different point, but similar skepticism, and it's cutting, both ways, liberal and conservative.
If there's one thing you take away from my argument today, it is this. And let me be crystal clear. Without the release, the plan will unravel, Chapter 7 liquidation will follow, and there will be no viable path to any victim recovery.
That was attorney Pratik Shah urging the justices to greenlight the $6 billion settlement involving Purdue Pharma. Jonathan, wonder if you can talk to us a little bit about the future implications of the case if the court were to side against Purdue Pharma. Is Shah right that there likely won't be any relief for the victims and their families?
That's really hard to say. Obviously, what Shah was arguing, and a lot of proponents of the deal who represent the interest of opioid victims have been adamant for years now, as this has been tied up in appeals, that this is the best and only deal available to opioid victims, and without it, there's a whole parade of horribles that will happen, including a loss of up to $6 billion that could, help address or rectify at least some of the harm caused by Purdue. They've accused of obviously fueling the opioid epidemic. What will happen? I don't really know, but Purdue and proponents, including victims who have no love lost with the Sacklers, say there will be nothing left for victims if this is unwound by the Supreme Court.
What happens, though, if the court sides with Purdue Pharma? What is the government saying will happen here?
Yeah, that's a good question. They're much more like a straightforward argument, being as good as this settlement might be for everyone involved, it's not permitted under the bankruptcy code. It's kind of that simple. They also say that if the deal is unwound, well, Purdue and the Sacklers, they're just going to have to make a different deal. They're not preventing anybody that wants to be a part of this deal from consenting to it. The problem is forcing people that don't consent to it to take it. So what the Justice Department is saying is that, look, if this goes back to the bankruptcy court, they'll just have to work out another deal, and potentially that would mean maybe the Sacklers would have to put up even more money than they already have to buy peace, and it doesn't prevent anybody that wants to be a part of this deal from being a part of the deal. It just prevents people who don't want to be a part of it from being forced to take it.
So reading the tea leaves on a Supreme Court argument is always a very dangerous game. That seems particularly so in this case. Did you get a sense of where this is actually going to end up at the end of the day?
No. I wish I did, but I think the most interesting thing is getting justices that wouldn't otherwise agree kind of raising similar arguments, or kind of being in agreement either against the deal or at the same raising questions about the challenge to the deal. I kind of found interesting.
What about the broader impact here? Is there any concern that this deal could upend bankruptcies in general going forward?
For sure. I think this was what the Purdue lawyer said, that what is at risk here is potentially the Justice Department taking a wrecking ball to the bankruptcy code. These types of settlements are pretty common when companies that are overwhelmed by lawsuits wound up in bankruptcy. And if the Supreme Court says you can't make this type of deal, maybe it means that companies that would file bankruptcy to try and come to some sort of grand settlement of litigation, maybe they don't file bankruptcy in the future. So if the Supreme Court agrees with the Justice Department, it would have pretty broad implications for bankruptcy in general and its use as a forum to resolve this type of mass litigation in the future.
Wow. So lots to watch for in that case. That's Bloomberg News reporter Jonathan Randles. Thanks so much for joining us.
Thanks for having me.
By the way, the Sackler family denies all liability and hasn't been criminally charged. And that does it for this edition of the Bloomberg Law Show. I'm Lydia Wheeler.
And I'm Kimberly Robinson. This is Bloomberg.